Good evening, Captain Retired Matt Edwards here. Figured I'd do another video. I haven't done one in a while. Everything seems a little dark. I don't know why. However, now it seems almost too bright. Well, I'll leave the flash on and see what happens. Okay, going back to my numbered list, that's what I was doing in these weekly videos I was doing. I'm not going to try to be too long tonight. But anyway, going right into the list, and after I do 3 items, usually I usually do 6. I'm going to talk about the last 2 days. I've been kind of triggered about something. I was trying to get back into the swing of things, and lo and behold, read something that pissed me the fuck off. So, number 445 on the numbered list that I created, negative unjust enrichment in the Peel Supreme Court of Canada case. Now, an unjust enrichment is when one party is enriched unjustly at the expense of another party. And they said that you could have a negative unjust enrichment if you saved on a cost. Now, think about clawbacks. Clawbacks are a form of negative unjust enrichment. There's no way they can justify them, but they do them anyway, and it harms one person at the benefit of another. Now, number 446. Canada Pension Plan Disability clawbacks only when any occupation definition is certified under long-term disability, unlike what Manulife does. You see, Canada Pension Plan Disability is an any occupation long-term disability insurance. So, if you're going to compare apples and apples, you have to wait until the person satisfies the definition for the Canada Pension Plan, any occupation, and then you also have to satisfy the definition of the any occupation under the long-term disability plan. But they don't want to approve people past 2 years on the Service Income Support Insurance Plan, Policy 901-102, for example. But yet they want the Canada Pension Plan to defray their cost. Number 447. The duty to act honestly in utmost good faith. Now, in all contracts, there is an implied duty of good faith. That means you can't lie, cheat, be dishonest, right? But in an insurance contract, there's a higher duty, the utmost good faith duty. So, the Government of Canada has entered into the utmost good faith duty with respect to the Service Income Support Insurance Plan, Policy 901-102, and I would argue with the income replacement benefits of the Veterans Affairs Canada system. Now, I still got to touch whatever infection I have. Thought I was over it, and then I sneezed today and caused a bunch of gunk. Anyway, so those are the 3 items I'm going to cover from my list now. I'll save where I was. And I'm going to talk about a couple of things that really pissed me off enough that I started phoning people and try to get a hold of people. Not that I did. So anyway, here's one of the items. Now, there was in 1998, the National Defense and Veterans Affairs Committee was investigating certain things, and the Service Income Support Insurance Plan was one of them. And the president of the Service Income Support Insurance Plan at the time was Dave Roberts. Now, he was called before the Senate as a witness, and part of his testimony, he said this, which I would disagree with most vehemently. He said, what people fail to understand, or what there's a misconception about out there, is that somehow this is a private company, and we should be paying whenever somebody has a problem. Well, that's the way insurance works, buddy. If you don't want to be in the insurance business, then don't sell insurance to people who, if the risk happens, you have to pay to them the insurance that you sold to them. In fact, the CPPD benefit is made up of 4 components: the Canadian Forces Superannuation Act, which is the member's pension plan; the Pension Act, which is essentially a benefit that is payable if somebody is hurt on duty or in a special duty area; the Canada Pension Plan; and then CPPD. Now, what he's trying to say, illogically, is that these 4 benefits combine into one payment. He's trying to say that they're integrated. But he doesn't have the authority to speak to anyone about the Canada Pension Plan. He has no authority to speak to anybody about the Canadian Forces Superannuation Act pension. And the Pension Act, that's none of his business. Now, reading between the lines, what he's saying is that they are going to be the last payer, that they will only pay if you don't have any money coming in from any other source. Now, the Pension Act was struck down in the Dennis Manouche class action in 2012 in the federal court case. But that's another reason I was so upset. This wasn't a quote that had me so pissed off. You see, I was looking up, trying to figure out, compile the various estimates of the Manouche case class action damages, how much they would be. And in one instance, they said in 2007 that they estimated it to be about $5 million. Let me see if I can find where I had that now. So, I don't know the source of this, but it's paragraph 53 of wherever I found it. According to Mr. LeMay, who was the president of CPPD at that time, it was Roberts, and then it was LeMay, and then it was Andre Bouchard. The formula for calculating CPPD long-term disability benefits, which provides for deductions of other income sources, was taken into account in the development of the CPPD long-term disability policy, its funding, and the premium charged. This is the type of program that Treasury Board agreed to pay in order to provide an income replacement of 75% of the member's salary minus other income sources. Mr. LeMay indicated that this was an industry standard for long-term disability benefits. I don't care if it's an industry standard. If they're all in the industry breaking the law, then you shouldn't follow them. According to a 30th of May 2001 letter from Maritime Life to Mr. LeMay, it is estimated that it would cost at least an additional $5 million per year to exclude the Pension Act deductions from the long-term disability policy. Now, this is what pissed me off. Okay. So they looked at the cost of how much would cost the government if they chose to end voluntarily the CPPD, the Pension Act clawback. It was 2001. The Ombudsman, Canadian Forces Ombudsman report came out in 2003, 2 years fucking later. I had always presumed that the Ombudsman was a source of, we got to fix this problem, but they knew there was a problem in 2001, 2 years before the Ombudsman report came out. Now, such a change would require the consent of Treasury Board. According to CPPD figures, approximately 56% of CPPD long-term disability clients also receive the Veterans Affairs Canada pension benefits under the Pension Act. Now, that's good information. That's facts. The majority of the people at that time that was receiving CPPD were injured in service. They were also getting a pension. But you know, the problem with that is there were other people that had too much money being deducted from the Pension Act or from the Pension Act plus other things like the Canadian Forces or Canada Pension Plan pensions that were zero sum, and they didn't get any money at all. So the thing is that another point I would make is that Treasury Board Secretariat, who I've seen references to, they sponsor and own the policy. Well, they don't. See? They transferred the policy. They're excluded by law under National Defense Act, Section 41.3. So they cannot own have anything to do with assisted long-term disability, because assisted is non-public property under the National Defense Act, Section 39, and therefore the public has no interest in it. Which, by the way, just occurred to me that the Department of Justice idiots in paragraph 87 of the Manulife statement, Manulife affidavit, they said that the public had an interest in keeping costs low. Well, no, they don't, because it's non-public property. If it was public property, they'd have an interest, maybe, but it's non-public property by law, because it was established under Section 39(1) of the National Defense Act, which is about non-public property. So anyway, that was the first estimate. Now, later in 2007, they said that they thought it would be anywhere between $270 million, they said, in the 2007 report to the Canadian Forces or Treasury Board by Manulife. And they said if you go back to the year 2001, that it would cost $270 million. And they said it would be $500 million if you wanted to go back to 1985. So now we have different figures. It makes me wonder if we can trust their math, because they should get it right the first time. We're talking significant amounts of money. Why can't they be competent enough to come up with good estimates? Now, one of the things I talked about in a post today was the fact that well, I just lost my train of thought. I'm not even going to try to get back. Oh, here's what I was going to say. When you look at the Dennis Manulife class action figures, and I've repeated this in a standalone video I did about 8 minutes long earlier today, they gave retroactive payments of $331 million. Now that is damages, not income. Then they had tax gross off of about $11 million. Then they had a scholarship fund of about $10 million. Then they accounted for $83 million worth of interest. Then they had reserve amounts, which I presume is how much money they're going to put into the bank to pay future claims. And that was $199 million. They allocated to any occupation zero sum. So that's a 3A disabled veteran. And for the own occupation zero sum, which is a 3B disabled veteran, they had $14 million allocated. On active claims, people that they didn't kick off yet because they have a habit of kicking everybody off at 24 months, is $188 million. Now, and then the total was $888 million. So there's a lot of money involved. And I should go down and see what the other point I thought of that I was going to mention. But these people don't seem to understand what insurance is supposed to do. Okay? What you're supposed to do is collect a bunch of premium, put it away, and then pay out the claims. Now, the Department of Justice, in its stupidity, they said, and I'll go up to the picture of it when I find it in a second. In the case at bar, legislation and insurance policies which provide benefits and pensions to civil servants must balance the interest of those servants who receive benefits, those servants who pay premiums into the program but do not receive benefits, and the taxpaying public of Canada, who bear the burden of these benefits. No, they fucking don't. These members who receive assisted long-term disability have an interest in receiving the maximum amount of benefits possible, while members who pay premiums but do not receive benefits and the members of the Canadian public at large have an interest in minimizing the premiums that they must pay. Bullshit. Bull fucking shit. You pay insurance premiums for peace of mind, that if the risk happens, you will get the insurance that your premiums paid for. Now, they lumped the public and the serving Canadian Forces members who haven't become disabled in a contradictory, conflicting position with the disabled Canadian Forces members who lost their career and ended up getting assisted long-term disability. But they're the same group. The people that get paid claims come from the people who used to pay premiums. It's just insane that the Department of Justice would try to separate the group when there's no separation. Now, here's another point that I thought of in relation to pensions. They're talking about these things being benefits. Well, when does it become a benefit? Is the benefit the premium that the government pays on your behalf, which I call salary? Or is it, if you become disabled, you then get the benefit? Well, there's an argument to be made there. Now, the thing is, what we're dealing with is fraud. So Manulife makes the payment, and to all the casual observer would think that Manulife underwrites the policy. But Manulife doesn't take the risk of property loss. They don't underwrite the policy. It's the government of Canada that underwrites the policy. And therefore, they're lying. Now, remember what I was talking about utmost good faith? So they've broken the contract. The contract has an implied duty of utmost good faith. And when the Department of Justice mentions in the affidavit trying to say that there's a conflicting interest there, when there is no conflict of interest, they violated the implied duty of utmost good faith that's put into the assisted policy. I'm kind of getting tired of this, and I want to keep my first video, since I started the duties, short. But I'll mention how the same thing applies to pensions. Now, according to all the employers that you would ask, including the Government of Canada, a pension is an expense. Well, then if it's an expense, how come the Supreme Court of Canada in Nolan, 2009, they stated that the employer gets a bunch of benefits? Like, they're not the primary benefit, but they do receive a benefit from a person's pension. Now, I submit it is common sense that the employer can't say that the pension is an expense when they also get a benefit from it. It can't be both. It's either black or white. It's not gray. Okay? So, as an example of that, I'm getting back to the misleading, the gaslighting that the government is doing with us. Well, they say that the taxpayers are benefiting from clawbacks. But in fact, it is my submission that the tax base is hurt by clawbacks, because the more money that you receive, you will get taxed on. So by clawing the money back for the Canada Pension Plan or the Canadian Forces Pension or whatever, then the person doesn't pay taxes because the underwriter or the insurer clawed back the money. So the government is out to taxes. Now, a lot of people look at me and say, well, the government pays taxes and the government collects taxes, so there's not much difference. I mean, but think about in the non-governmental employer who offers their own administrative services only policy. And there's a lot more of them, I would bet, than the government of the provinces and the Government of Canada. So all of the combined employer-run administrative service only policies, when they claw back, they save money, and they save money at the expense of the tax base. I think it's a good public policy argument that would shoot them out, just like shooting fish in a barrel. Them stupid fuckers have created a trap for themselves. It reminds me of the thing with Donald Trump. He's one of the people I watch on YouTube and stuff, and seeing him go down, hopefully for all these crimes he's committed, the fraud and whatever. And the other day, his argument the lawyers made for him about the complete immunity, absolute immunity for a president, so he cannot be charged for anything when he's the president, whatever he does. Now, by the way, Canada has many immunity clauses as well built into it. It had absolute immunity until 1953, when the Crown Liability and Proceedings Act was enacted, allowing the government to be sued. Before that, you could not sue the Crown, no matter what it did to you. So, back to the absurdity of the argument. The judge was hearing the appeal, and I heard this with my own ears because they had the recording. They asked the judge, they asked the lawyer for Donald Trump, listen, according to your argument that the person would have absolute immunity from prosecution if they were doing something in the office of the president, if the president ordered SEAL Team 6 to kill his political rival, could they be charged criminally? And the lawyer said no, basically. He said, well, if you got impeached by the House of Representatives and convicted by the Senate, then you could get charged criminally. But you see, a few months ago or a year ago, the Senate committee, the Senate in the U.S. said the exact opposite. When they decided not to impeach Donald Trump, they said, well, he can always be held accountable in a criminal trial. So that's what I'm saying. You can't have it both ways. Okay? You can't have it both ways. You can't say that the president can only be convicted in a criminal trial if he gets convicted by impeachment first. But then say when you're not impeaching him that, well, you know, there's always a criminal trial method. Well, these people have been getting away with murder for the CPPD and the Veterans Affairs system. They're treating disabled veterans like dirt, worse than animals. For example, I know I meant shut up, but I was looking at the facts and figures about Veterans Affairs and the clients they serve. And one of the things that got me hot and bothered was they talked about the income support program. Now, I've spoken about this a lot. If you have a person who puts their life on the line for Canada and they become injured, they get compensated for the injury, and they're not getting income support, which is welfare. Okay? It's almost like workers' compensation. So you gave up the right to sue in order to get compensation. So you're not getting something out of the government's largesse. You're not getting charity. You're getting something because they took your right to sue, and you get compensated instead. So I'm 100% certain that the government believes that it's giving out charity, or it doesn't understand what income support means. Because someone who gets injured and is getting paid to balance the scales, because that's what a tort lawsuit does, and Veterans Affairs and workers' compensation are both replacements for a lawsuit in tort. So these are supposed to balance the scales when someone injures you. So if you're getting a debt payment that is not a profit, well, the Income Tax Act, for example, says that you had to make a profit in order to get taxed. Well, if you're getting money to repay what you're owed, that's not a profit. So therefore, and you paid the cost of the right to sue to get it. So if you subtract the cost of the right to sue with the amount of money you're getting, you have a zero sum. See? They don't seem to understand this. Now, again, I mean to shut up, but here I am. The administrative services only issue that the government is refusing to admit will sink their boat eventually. Because they're lying. They're lying through their teeth. Okay? Manulife didn't get sued. The government of Canada got sued. So you can just look at that one fact for the RCMP. It was the Butte Estate case in 2012. And for the military, it was Dennis Manouche versus Her Majesty the Queen in 2012. Those cases did not have Manulife mentioned. Now, on that note, again, these are things that occur to me, and I'm afraid that I'll forget it or whatever. When you look at the Administrative Services Only Canada Revenue Agency cases, Canada Revenue Agency takes the position that these monies are income paid by the employer, and they're supposed to take Canada Pension Plan and Employment Insurance Act. Now, they don't. So it's a pretty powerful argument that you shouldn't pay tax if the government, who underwrites the program, pays out insurance monies, but they don't take Canada Pension Plan and they don't take employment insurance out, despite the government writing laws that said long-term disability plans that are administrative services only have to deduct these amounts. Plus, you have what's called the unclean hands doctrine, or the doctrine of illegality. So the government passed a law under the Canada Pension Plan Act, Bill C-13. And that stated that if you're an employer and you don't actually buy insurance from another company and you run your own insurance, but you hire someone to administer it for you, well, then you have to pay CPP premiums. But that was in 2011, and for the past 13 years, the Service Income Support Insurance Plan has ignored that law. Now, if you want to win a case, say if I or someone else took this case to trial, you're not going to win if you're acting unlawfully. So you point out to the judge that they have breached the utmost good faith implied into every contract of insurance. They have misrepresented themselves in saying that Manulife is the insurer when Manulife is not the insurer. They only administer the policy. Then you point out that, well, the government is actually cheating disabled veterans hurt in service Canada. Like, for example, the Dennis Manouche class action, they recouped a lot of the money that they paid out in taxes. And you just have to ask the question, is the tax system designed to mitigate damages? Now, clearly, that is not the case. If you get paid damages, Canada Revenue Agency has a bulletin they put out called IT 365R2. And that states that the damage you get to settle a law dispute is not taxable. Now, if you look at Income Tax Bulletin 428, which is about long-term disability plans, they try to claim that long-term disability plans are taxable under two conditions. The first one is if the employer, if it's a periodic payment. The second one is if the employer paid part of the premium. Now, if you look at the payment from the Dennis Manouche class action to the people that were harmed by the government, it was paid as a lump sum. Now, a lump sum is by definition not a periodic payment. So the first question they should have said is the payment that was made to these disabled veterans, was it periodic or was it a lump sum? When the answer comes back to the questioner, it was a lump sum. Okay, they say, then no T4A will be issued, no taxes are due because that is the law. It isn't an interpretation of the law. The word in the Act under Section 6.1F of the Income Tax Act says the payment must be periodic. Now, let's look at the other condition. It says that the employer must make a part of the payment of the premium. Well, I never found it yet, but I have to look it up. There's a case I read once that they were talking about damages and the reduction of damages and who paid the amount of money to get the insurance. And they said, why should the person suffer because the employer paid the payment on their behalf, when if the employer had paid the employee the money and the employee had then bought the insurance with the money that the employer gave him, you can't draw artificial lines like that. It should be roughly the same, right? So when the government says it pays 85% of the long-term disability premiums for the service income support insurance plan, well, really it's just paying salary to the serving Canadian Forces member in the form of, if they pay it. I don't trust the government, so I don't know if they actually make the payment. They might put on paper that we will pay 85% of the long-term disability premiums, and you will pay the other 15%, and they deduct it from your pay. I don't trust them. Now, why don't I trust them? I'm not paranoid, I don't think. After the Manulife case, under the Service Income Support Insurance Plan, in their report, they put that they had $300 or something million in premiums in the year that the damages were paid. You can't call something premiums when you are accounting for it to put it into the fund so you can then pay the money out of the fund to the disabled veteran who won the lawsuit. Now you might say, well, the government can do what it wants, but that's not true. Trying to remember the name. I think the name might be Roberts. It was a Newfoundland Court of Appeal case that I was looking up about the Pension Act pension. And the Pension Act pension was put into the bank. And because it was put into the bank, some people might say that you can garnish it then. You can't garnish the payment from Veterans Affairs, but you can garnish the payment from the bank. But the judge said that there's no change in the legal characteristic. Once you deposit it into the bank, it still came from the Pension Act. Well, if the government put the money into the CPPD policy program to pay out the veterans from the damages from the case, and they called it premiums, you can't then call it income. You know, you can't be two-faced about it. You can't be acting so absurdly that you would call it premiums when you're putting it in. I mean, maybe they had to call it something, but maybe they could have called it other money or something, but it isn't a premium. It's not someone's money that's a member of the Canadian Forces paying money in anticipation of insurance. If they become disabled, then they get the insurance. This was after a court case, after they lost, and it was to settle a case. So I believe the government perjured itself of a sort, because it stated for the public record that this money was premiums. No, I highly doubt anybody will ever sue the government or charge the government with falsifying records. But they're doing it all the time. If you get the Service Income Support Insurance Plan, and I see Gerard's watching, if he's still getting his long-term disability, the same thing probably happens. Great-West Life might pay him the money, and they might put the T4A if he gets a tax information slip from Great-West Life saying Great-West Life paid the money. But if it's an administrative service only policy, then the employer or the former employer paid the money to Great-West Life, and then they just redirected the money to Gerard. So Great-West Life never paid anything. See? So for Manulife operating the Service Income Support Insurance Plan, they get to have a pretty big expense to reduce their profit. So that costs the Canadian taxpayers money, because, well, Manulife has an expense that they didn't actually pay. The government paid the expense, but it was accounted for falsely, and, well, Manulife would be stupid not to claim it, because they made the payment. So they would say, well, we made the payment, we can claim it. But see, that was the crux of the cases that I mentioned before about Canada Revenue Agency in 2002 and 2003. Manulife was administering the policy for the University de Laval and National Bank of Canada. They said that even though the payment came from Manulife, technically, it was really coming from the employer. And that was the basis of making them pay employment insurance premiums. They looked at the source of the payment, and they were correct. It did come from the employer. But they forgot to ask, why is it being paid? If it was being paid for services rendered, then it's income. But then you wouldn't have to put it on a T4A tax information slip. You put it on a normal T4, because the person would have been giving his employer services in exchange for money, which is income. But if the employee gave premiums to the employer and the employer underwrote the policy, then the person becomes disabled. Then the payment is coming in relation to the premiums that entail the person to payments under an insurance plan, and therefore the person is getting insurance proceeds and not income. Now, the reference for that one is Cunningham versus Wheeler, Supreme Court of Canada, 1994, and the question before the court was, when persons that were injured in a car accident were getting long-term disability payments from a group policy, the Supreme Court of Canada had to decide, is this receipt of money? Is this income or insurance? They didn't say it can be both. They said, is it income or insurance? Now, I say the same thing for the CPPD and workers' comp and Veterans Affairs Income Replacement Benefit and almost anything of these types. Is it income or something else? Now, if you're getting money in relation to payment of damages, then it's not income, it's damages. If you're getting money from an insurance policy that you bought premiums and there's no guarantee you might ever get hurt, then it's insurance. If you pay money into a pension and the contributions toward the pension aren't taxed at the beginning, they're not taxed when it's vested in the pension, and they only get taxed when you take it out, there's a technical argument that it can be taxed because they should have taxed it at the beginning, or they could have taxed it in the middle. But they chose to tax it at the end to try to encourage employers and employees to have pensions for retirement, to save the government money in welfare. Because if people spent all their money when they earned it and didn't save anything for the future, then the government would end up supporting those people with social insurance, social assistance. Listen, talking long enough because I had meant to only do it about 20 minutes or so. Thanks for watching, and I'll try to be more regular with these, probably once a week.